while they're getting ready, I'm back. This panel discussion will really be a casual chat about some of the issues that we've seen crop up quite frequently in the past few years in our world of IP. And these are really spurred on by some of the technological advances that Justin so nicely set out for us. So I will just get into it immediately. We only have 20 minutes. If you have a question and we have time, please jot it down and we'll try to get to it. So first up, Johnny, I think I want to chat to you. We have a lot of clients, a lot of queries coming up about apps and how protectable they are. Can you actually tell us, just give us a quick rundown, are apps protectable? And if so, how?
Right, yeah. So firstly, I'm a patent attorney, so I deal with these patent applications on a wide range. And certainly lately, the patentability of apps has become a regular topic, and we often advise the clients on this exact topic. My own view on the patentability of apps is that it must still meet the basic requirements, and that is that of novelty and inventiveness. If those two requirements are met, then I see no reason why those can't be patent protected. There are a number of detractors of that sort of concept saying, well, software inherently is unpatentable, but I tend to disagree. And I think if you look at the filings that are being done and the way the specs are being worded internationally, certainly supports my view that provided those requirements are met in terms of novelty and inventiveness, then there's no reason why one can't file a valid patent for a software app.
And a valid patent gives how much time frame for protection for that app?
Well, a patent in South Africa lasts for about 20 years. That's a worldwide thing. Most patents last 20 years. You first normally file what we call a provisional application. That's just to get your foot in the door, which you basically set out your idea. That gives you 12 months to develop and test and market and improve the app to a point where it is a commercially viable solution. And at that stage, hopefully, that would take place within 12 months, or sometimes, obviously, it takes longer, so the timing becomes an issue. But you then file what you call the complete application of the 12 months, and then the complete application would then go through to grant in the various countries that you filed it in.
Just out of interest, have you had any, are you aware of any patent cases that have enforced rights in an app?
Not in South Africa, no.
Not in South Africa.
Internationally, certainly, yeah.
And what is the general feel or direction that those cases have taken, if you've had a look at any of them?
Generally, I mean, obviously the validity of the patent is always the first question mark. If the patent is valid and there's infringement, then either there would be damages or some sort of a negotiated way out of it.
Okay, thanks, Johnny. I think I'd like to move on to something not quite related to apps, but it does come up a lot on social media, and that's hashtags. I mean, hashtag IP Crammer. I hope that's trending on Twitter. Even if it isn't, though, I think it's quite important for us to find out, Ian, can hashtags be protected as brands?
Yeah, I think the first question to that is why would you? And the simple answer is if you look at the huge presence you can get out of them. So we've all seen hashtag fees must fall and hashtag Protea Fire and all the rest of it. None of that's particularly commercially relevant, but if you tie it into your normal marketing strategies, you get a massive benefit. And I'm not a marketing guru, but I'm told these numbers are significant. There was a campaign in the US, hashtag #eSureAndSave30, that generated 200,000 tweets in 60 seconds. Okay, and each of those is a direct interaction with your client. That particular campaign, over the course of its life, had its hashtag viewed 2 point something billion times in like a year. So there's huge commercial value, and the question is, how do you protect it? And that depends a little bit on what your brand is. So if you're talking Adams and Adams, well, do you really need a hashtag for hashtag Adams and Adams? Adams and Adams is hopefully quite significantly protected. It's got a reputation that adding a hashtag to the front of it isn't that relevant. But if the hashtag itself becomes a key component of your campaign, so like in that scenario, hashtag #eSureAndSave30, you're starting with a brand that's not the strongest to begin with. eSurance for insurance, I assume, is not quite strong. And then, but the hashtag added to it, plus a little bit of your campaign, makes it a much more stronger, much more unique brand, and then you can get better protection through the addition. And the thing there to remember is, if you want the stronger hashtag, it must be clear that the protection you seek is a hashtag. So if you're going to protect hash symbol and then 1, it's not going to be immediately clear that that's a hashtag you're protecting. It might just be a numeral 1 device you're protecting. So you want to make sure from how you protect it that it's properly formatted, is functioning as a hashtag, and then also just the general rules. If your complete mark is not distinctive, it's not going to be protected. So it has to identify to the consumer who you are and that this is your brand. And if you can do that, then you can definitely protect it.
So you're suggesting that it's actually a combination, the hashtag together with your marketing campaign?
Yes, and it's also one of these things where you have to decide what is your strategy. If the idea behind a hashtag is that you want people to use it. So if, for instance, we got trademark protection for hashtag IP Crammer, and then we got super aggressive about enforcing our rights against anyone who used it, well, that's a little bit counterproductive. You want people to go out into the market and use it. So you have to make a decision as to which hashtags are going to be proprietary and how is that going to be controlled. If you clearly want to stop your competitors using your hashtag, if you've got hashtag eSuranceSave30 or even hashtag Save30, you want your clients to use it, or you want your customers or potential customers to use it, but you don't want your competitor to be using it to attract custom. So in addition to whatever protection you can get, you do need to come up with quite a sophisticated campaign or guidelines as to when are we going to enforce, how are we going to enforce, and what is the benefit we're going to get from enforcement.
Good. Have you seen any successful campaigns using hashtags in South Africa commercially? I mean, I know you mentioned Visma's Fall, but there's nothing commercially there.
Yeah, well, I mean, depends what you define by commercial, I suppose, but if you look at any of the campaigns, eSurance is easily the most successful one globally, or certainly that I could find, maybe some more recent ones. Hashtag MyKelvins has done it very well, which is, it links into other social media, but it's specifically looking at, the idea there is you buy a pair of Calvin Klein clothing, although it's turned out to be exclusively underwear that the campaign is really used for, and then you tweet or Instagram a picture of yourself with a selfie, hashtag MyKelvins, and what they've generated there is essentially a massive advertising campaign with unique content people are looking for. You know, you'd pay a lot for a model to take a photo of herself in underwear, less so if it's, random off the street. And, that generates huge amounts of success. Protea Fire is generating a lot of success. You're seeing it quite a lot.
And they're South African.
Yeah.
Yeah. Okay, good. Thanks, Ian. I think I'd like to move on to something else now, completely unrelated, 3D printing. Reinhardt, I recently read an article that said that you can virtually get just about anything 3D printed. Is this a revolution, or is this actually destructive to intellectual property?
Thanks, Lita. It was interesting for me to see that Justin also touched on the, the different kind of industrial revolutions. And there was, I think it's a futurist called Jeremy Franken, and he said that the 3D printing marked the beginning of the third industrial revolution. Now, whether human tissue being created or replacement organs, plastic guns, metal guns, is in fact that kind of revolution that we're talking about. I'm not too sure. It's not happened as rapidly as we expected, but we are seeing a lot of manufacturing plants using 3D technology, and we're also seeing that the costs are coming down for a lot of domestic and household kind of printers. At this stage, I mean, there's a wide variety of products that are being created. So some of the more interesting ones are specifically within the medical field, but it's really about the kind of substance that you want to use, and I mean the possibilities are really, I mean it's legio. So and then you're also seeing some examples in Asia where they're actually duplicating houses. So
Wow.
So that's just on the creation side, but on the side of intellectual property, I mean, the big question is actually who owns that 3D printed matter. And I think if you start looking at copyright law in South Africa, the general rule is that the author is the owner, certain to subject conditions. Now then, the creator of the 3D design might well be the author, because we've got provision for artistic works and for works of craftsmanship. Whether the Copyright Act in South Africa in its current format actually sufficiently addresses that is yet to be tested. And in addition to that, when you've got more than one party that's part of this process, so you've got the designer of the product, then you've got the draftsman who's actually preparing this CAD drawing, you've got someone who's operating the 3D printer, and to the extent that all of them are actually contributing original material, there might be some joint authorship issues to consider as well. And then, yeah, with regards to infringement, I mean, creating a product from this 2D protected copyright work might be constitute infringement, but there is some exceptions when you start looking at fair dealing and fair use. But this is just on the copyright side. It's really important just to be proactive when you're managing your intellectual property and look at some of the intermediaries, digital rights management. How is the CAD files actually coming onto the internet, and how are you actually regulating that? Yeah, so that's just on the copyright side. But I mean, it's really like an interaction of patents, copyright, trademarks, and even trade secrets.
You
So-
basically kind of stole my question. I was going to ask you, out of that IP recipe that Nick
Yes.
mentioned in his earlier talk, you've just touched on
Yes.
copyright, but what other rights feature when we're dealing with 3D?
So I mean, if you're
printing?
thinking about patents, Johnny has now mentioned some of the requirements, novelty and inventiveness. So to the extent that you're actually developing some new technology within that space, there might be a new methodology that you might be looking at protecting. In the United States, I've seen that something like isolated DNA sequence has not been eligible for patent protection, but something like a printer that's created a DNA string in some synthesized form appears to be eligible. And just with regards to patent infringement, the real difficulty is, how do I know that the person there on the corner of Grayston Drive is not infringing the new human tissue creation invention I have? And also, is there actually any merit in trying to institute some kind of action against that party? So I think then what you need to look at is who's actually facilitating the 3D technology, who's providing those the CAD files, but then also when you're looking at contributory negligence,
Yeah.
would the person have been reasonably aware of the patent? Also interesting with something like trade secrets, there was a case internationally of a jewelry maker who was successful for instituting action against his ex-employer for the misappropriation of trade secrets, where this employer actually got hold illegally of some of the CAD files. He then bought a 3D printer and made some wax models, and the court found that CAD files constituted valuable information and it was secret, and he was actually successful with that. On the trademark side, we're seeing a lot of products that now can be created easier and cheaper, so the counterfeit market will grow year by year.
Yeah.
Then also on the design side, and then a bit unrelated but also still related is something like product liability, where every second homeowner is now seeing himself as a semi-qualified factory worker. So you might have a situation where there's a lot of defective products also entering the market. And the question is whether the CPA would be able to address that properly. I mean,
By that, you mean the Consumer Protection Act?
Consumer Protection Act. So when you're looking at the supplier and the manufacturer, is it the person that's providing the 3D printer? Is it the person that's providing the materials for the 3D printer? The person that's creating the CAD files, or the person assisting with the whole system? So yeah, in a nutshell, that's some of the issues to look at. So no, the robots aren't here yet, but they're surely on their way.
And we
Yeah.
should be ready when they get here.
Yes, definitely.
Absolutely. Okay, something totally unrelated. Nick, I want to talk about memes. I know Justin touched on it in his talk earlier. I think they kind of take a life of its own, especially over social media. You use memes to communicate whatever you want to say right across, on social media platforms which are accessible worldwide. What I want to find out from you is, and I know you have a quick presentation for us on this, what kind of legal implications does one run into when they start using memes, especially in advertising campaigns?
Thank you, Lita. So the first thing about memes, which is in your pack, is that it's the dictionary meaning is an idea or belief that's spread from culture to culture over time. That's on the, do you mind putting up the first slide?
Am I supposed to point here?
Or just push next. I'm sorry.
Okay.
on the thing.
Sorry, I'm not very computer
Okay.
literate.
That's all right. Okay. Yeah. So the traditional idea of meme is ideas being spread from culture to culture. So, and that word's been in the dictionary for hundreds of years. But the second meaning, the way we understand memes, is in the internet age, and the ideas that and the trends and stuff are a lot easier. They can go viral a lot easier. So, I'm sure some of you will be familiar with the "Ain't Nobody Got Time for That" meme. And then I quite enjoy this "Who Wore It Better," which is a meme in itself. A lot of people go to work dressed the same and put up on Instagram "Who wore it better," and in this case we've got Donald Trump versus a piece of maize, which is awesome. And then the "Hey Girl" meme with Ryan Gosling is also very popular. So just an idea of the kind of ideas that spread. Karima Sheikh was due to speak on this topic, and unfortunately she couldn't speak today, so I came in. And I think Darren asked me to speak because I created a meme in the office the other day, which got a little bit of people laughing a little bit. And so we can go next. What happened, the context for the story was that I found a picture of Darren in a corporate brochure with sweeping the floor, which I thought was hilarious. So I thought this is like meme gold for the office. So this is the picture of Darren sweeping the floor. And with a little bit of work in paint, I created a meme because I thought we can compare Darren here to Mary Poppins. And so I said, Mary, pop into my office, printed it out and stuck it on his door, and got quite a few laughs around the office. So on this one, it's a good analogy for us to explain some of the concepts of IP law. And obviously the most relevant one here, the first one that comes to mind is copyright. So there's copyright in the person that took the photo, or potentially the company that commissioned the taking of the photo would be the ownership of the copyright. I'm not the owner of the copyright, and I've reproduced this. And I might not have a defense available to me in South African law. In American law, there's a concept called fair use, which allows you to use images out there which under certain areas that are considered fair. In South Africa, the fair dealing exclusions are a lot more limited and probably would not cover my use of this image here. Yeah. So the second one is Darren's personality rights. And he could potentially argue that I've either infringed his right to identity, dignity, or integrity. So if Darren took massive exception to me creating a meme comparing him to Mary Poppins, who's awesome, then he could potentially, or his first step would be to get me in front of the Adams and Adams disciplinary committee and fire me. But he would also potentially have remedies in court. So there are two cases that relate to this, to the personality rights in South Africa. The first is actually two attorneys regarding the naming of a firm. And the second, which Darren will be more happy the facts are closer to, regards a celebrity in Miss South Africa, Batisana Kamala. So those are some of the areas that are at play in this situation. But generally, it's not an issue that anyone's ever come to us with about memes in South Africa, because most of the time it's in a fun sense and it's not really for commercial purposes. So to go and launch an interdict against me in the High Court to stop me from spreading this meme around the office would not be money well spent for Darren. But on the second situation, it gets a bit different if, let's say, a rival firm creates a meme about Darren, creates an association between Darren and their firm, then potentially you're stepping into passing off, or if he's trademarked his name. Darren, have you trademarked your name? Yeah. Then we could be talking about trademark infringements as well. So those are some of the overarching elements of IP law that would be relevant to memes.
Great, thanks, Nick. That's awesome. Well, I'm dying to know. What are you going to do to Nick after this? Are you going to sue him or not? Okay, one more quickly. Ian, native advertising. I know a speaker must have touched on it earlier today. I think it might have been Justin Spratt, actually. Is this area regulated? And does it pose any unique intellectual property concerns?
I think yes to both. Maybe just to back up a little bit, when we first floated the idea of this panel, we wanted to put a little bit of reading material out in front. You could read it and then ask us some questions. The massive irony of having a millennial problems topic and then giving you paper-based reading material is only now becoming apparent to me. But the native advertising is essentially any advertising which is disguised in such a way that the consumer on whatever platform it is, whether it's social media, whether it's a news website, whether it's TV technically, isn't aware of whether he's receiving editorial content or the content that he's looking for or paid for advertising. And the two things there are, there's confusion in a lot of ways. The one relevant to the regulatory space is how is this regulated and how are we controlling the risk that a consumer can't tell what is an honest review or independent journalism and what is blatant paid for advertising. And if you look at the example that's in the reading pack, you can see there's two types of advertising there. One that is clearly links to more articles written by Times Live as journalists, and then the other is just blatant paid for advertising with links to other websites who've paid for the privilege of having their link there. And the short answer is that is regulated. A little bit more detail, this type of advertising has always been regulated by the ASA. There's a set of guidelines on advertorial content and how it needs to be labeled and marked. But obviously a lot of the players in this scenario aren't members of the ASA code, so it won't be regulated. what has changed recently is the South African Press Council, which administers the South African Press Code, which binds all journalists, now requires a specific indication as to whether the content you're viewing is what they call editorial content, i.e. journalistic content, or whether it's advertising content. So the regulatory framework is catching up, and it's going to get better and better and more easy for consumers to work out what they're seeing and whether something is, for example, a fantastic review by an accredited car journalist on this new car, or whether it's been paid for by a car company, and on condition of we give you a car, you write a nice review.
Perfect. Thanks, Ian. I think time's up. Thank you to the members of my panel for giving us some solutions to these millennial problems.